All right, deputies, can you all hear me?
Yes, Your Honor.
Okay. Just let me know if you all are ready. I'm ready to begin.
Okay. We're ready, Your Honor. Ready.
Okay. Let me get everything. Okay. All right. Good morning, ladies and gentlemen. My name is Judge Marcus Thorpe. I'm one of the associate magistrate judges here in Clayton County. It is 11 a.m. here on April 18th of 2026, and today is your first appearance. A couple of announcements, ladies and gentlemen, that I will have here before we get started with this morning's first appearance that I hope will make everything run a little bit smoother. As we go through this morning, ladies and gentlemen, if you have trouble hearing me, please let me know. Excuse me, as there are a few things that I'll need to go over with you that I think will help. First and foremost, please listen carefully because hopefully if you won't have any questions, and I think that I'll be able to get everyone out of here as soon as possible. And for those of you that will be released today, hopefully that will be sooner than later. First and foremost, ladies and gentlemen, I am not here to try your case. I'm not here to take a plea. I'm not here to have any legal discussions with you about the specific facts of your case. The purpose of first appearance, ladies and gentlemen, is to inform you of the charges against you, to advise you of certain rights, to set bond on those offenses for which the court is authorized to set bond, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. Now, each of you, ladies and gentlemen, has rights, of course. Most importantly, you have the right to remain silent. I tell you that because I don't need more often than not, what happens is individuals will come up when I try to advise them of what they are charged with, and they'll begin to tell me specifics about your case or any legal defense you may have. As I said earlier, and if I did not, let me say it now, we're streaming live. And so anything that you say during this proceeding can and will be used against you in later proceedings. You make not only myself, but as well as the deputies and as well as those others around you, potential witnesses, if you begin to discuss your case. Now, in addition to the presumption of silence that you also have the presumption of innocence. You have a right to an indictment by a grand jury for felonies or by accusation for misdemeanors. You have a right to a speedy and public trial by jury. You have the right to compel the attendance of witnesses to testify on your behalf. You have the right to see, hear, and question witnesses who are called to testify against you. You have the right to testify on your own behalf or offer evidence in your own defense. You have the right to an attorney to represent you. And if you cannot afford one can be appointed to represent you if I determine that you qualify here today. And then lastly, for those of you all who are not citizens here of the United States, some of these charges may adversely affect you or immigration status. And so you do have the right to consult an attorney after the end of today's proceedings. Now, in addition to advising you each of what you've been charged with, I'm also going to discuss bond. Some of you will be allowed to post what are called unrestricted bonds for your release from jail, pending the prosecution of your case, and be allowed to go home today. There are three ways to make bond. The first would be through the use of cash. The second would be a commercial bond. And the third would be a property bond. Now, when I say cash, the example that I like to use, ladies and gentlemen, is if I tell you this morning that you are charged with, as an example, aggravated assault, and I tell you that your bond is $6,000 and you prefer to use cash, or that someone you know has cash that they can bring up to the sheriff's office on your behalf, they would bring that up. The sheriff's office would hold on to that $6,000 along with any additional fees that they charge. And then at the close of your case, that $6,000 will be returned to the person who paid it on your behalf. Now, if instead you prefer to use commercial bonding company to assist you, it's a little different. So instead, what would happen is the commercial bond puts up the bond for you. You pay anywhere from 10 to 15% of the bond to the bonding company. But the big difference from cash is you don't get that money back. And so the example again would be if I tell you your bond is $6,000 on an aggravated assault here today, you would roughly be responsible for about $750 to the bonding company. But again, at that example, that bond amount is not returned to you. Then lastly, there is what we call a property bond. Now, with a property bond, it's whether you or someone you know owns a piece of property, a home, a commercial building, land, anything of that nature. And then at that point, either you or someone you know will bring the deed up to that property to the sheriff's office, where at that point, the sheriff will hold on to it until your case is closed, and then they will return the deed to either yourself or to whomever brought it to the sheriff's office on your behalf. The trick there is with the property bond, you will need to have at least 3 times the amount of your bond in equity in the home. So if someone owns a home that you know and they're willing to bring the deed up on your behalf, they will need to have at least, in my example, $18,000 worth of equity in the property. Now, as a part of your bond, ladies and gentlemen, we're also going to talk about special conditions. There are those of you all who will have special conditions attached to your bond, meaning I will advise you either that you cannot speak to the alleged victim if you make your bond, or you are not to return to a particular place if you make your bond. Ladies and gentlemen, if I could do anything else other than this today, it is this. Please, if you do nothing else, abide by those conditions. When I say you are to have no contact, that means you must stay away and have no contact with the victim. You cannot call them, you cannot text them, email them, write them a letter, or contact them through social media. You can't even do something as nice as write them a song, as that will be a violation of this bond order. When I say do not return somewhere, again, please do not return. If you find that it was somewhere you were living before you were arrested, and I tell you you're not to return, and you do make bond, understand you can go back to that property, but only if you are accompanied by the sheriff's office here in Clayton County, and you do it within 10 days of your release. If, however, you do violate these bond orders, and the court considers your no contact intimidating or harassing, you could receive additional felony charges such as aggravated stalking or influencing a witness, which carry punishment of up to 20 years in prison and $20,000 in fines. In addition, let me advise that there are a few of you, I believe at least one person who I'm not authorized to provide bond today, either because that individual was on probation or based on the specific charges, I determined today that bond was not appropriate. Lastly, ladies and gentlemen, after I've advised you of what you're charged with, after I've advised you of what the bond is, we're going to talk about preliminary hearings today. A preliminary hearing is a hearing that you may be entitled to where the judge and yourself and your attorney are present to determine if there is enough evidence or probable cause to keep you detained on your charges and to keep your case moving forward. Okay? If you are charged with a felony, you are automatically entitled to a preliminary hearing. If you are charged with a misdemeanor, I'm going to ask you today whether you would like the hearing or not, because you don't have to have it if you don't want to. You could tell me, Judge, I'd rather move my case along a little faster, send it directly to the prosecutor and have them review it rather than have that preliminary hearing first. Now, for those of you that make bond that are charged with misdemeanors and felonies, you automatically waive your right to that preliminary hearing. So the preliminary hearing, again, is only for those people who remain in custody that are charged with misdemeanors who desire to have it. If you remain in custody and are charged with a felony, again, you automatically will get it. So with that, ladies and gentlemen, we're going to go ahead and enter the oath and then proceed with the first appearance. So if I could have everybody please raise your right hand. And then I'm going to administer the oath and we will go ahead and get started. You swear or affirm that the information that you're about to give here to this court, as well as any information you provided on your court-appointed application for counsel, is true and correct. And if it is, ladies and gentlemen, I need each of you to repeat after me and say, I do.
I do.
All right, you may put your hands down.
Generally, I have to go back in. The ladies, I'll come down first. So I'm strong.
You want to put them out or put
And I believe first up should be Miss Armstrong. Is that correct, Deputy?
Yes, that's Armstrong right there.
Okay. All right, and are you Miss Miriam Armstrong?
Yes.
All right. So Miss Miriam Armstrong, I have your information here. And so again, I just want to go over your charges with you, and I'll give you some information here, and then hopefully I'll be able to get you out of here pretty soon, okay? You hear me, ma'am?
Yes.
Okay. All right, so Miss Miriam, you are charged with one count of theft by taking as a misdemeanor and one count of obstruction as a misdemeanor as well. Now, Miss Miriam, I had an opportunity to review your information here this morning, the information that was provided to me.
It went out.
Huh?
It went out.
Incorrectly, or that the solicitor may not change the charges at some point and recharge you again. Do you understand that, ma'am?
You went out before you got to explain anything.
I was saying to you, I have dismissed both your charges. And so I was advising you that you're going to be released this afternoon, sometime this afternoon. But I wanted to be clear was, ma'am, I am dismissing the charges at this level. And so that doesn't necessarily mean that at some point, if the officer decides to correct what was done incorrectly, that they may not bring the charges back. But as of today, ma'am, you will be released later today.
Thank you. I have a
All right.
question.
Yes, ma'am.
Yeah. The officer, he took my Camaro and my phone, and I haven't been able to get any numbers, so I can't contact anybody.
Okay. No, so as
And
far
I
as
don't
that,
have-
ma'am, so I don't have any control over that. But with you being your case being dismissed, all of your property will be returned to you once you are officially released. And so anything that you need or anything that you're missing, you'll be able to get that stuff back at that point. Okay.
Okay, when I leave, I can get it.
Yes, ma'am. That's what I'm telling you. So once you are released here today, all of that information, anything. I'm sorry, Miss Armstrong. Give me 1 second here, ma'am. This computer is not. Give me 1 second. I apologize, Miss Armstrong. I think the computer has read it wrong. I think it mixed you up with someone else. Give me 1 second, ma'am.
Thor. So they keep this list to the side. Monday.
Mm-mm.
Can you hear me?
Yes.
Give me one moment here. There's something going on with this computer. Give me one moment, please.
Okay.
Okay. Is that better? Can you hear me better, Ms. Armstrong?
Yes.
Okay. I was saying, I apologize to you. My computer was acting up this morning that for some reason it transposed and put your information incorrectly. You were charged with one count of theft by receiving, one count of obstruction, ma'am. For the theft by receiving, the bond amount is $1,500. For the obstruction, is $2,500, ma'am. So you actually have a total bond of $4,000 here. Okay, and again, I sincerely apologize, but I wanted to make sure I clarify that. That's why hold up there for a moment.
Mhm.
Because you are charged with misdemeanors here, Ms. Armstrong, you do have the right to a preliminary hearing, or you can waive that right to the preliminary hearing. If you remember, the preliminary hearing is what I was talking about a little bit earlier, man, where I was describing to you. It's a hearing to be held where you are present, the judge is present, and they go over the charges against you to determine if there's enough evidence to proceed to the prosecutor. Okay, and you don't have to have it. It's not your trial. I can skip the hearing and send it right to the prosecutor's office if you would like instead. So it's really just how you would like to proceed. Do you have any thoughts on how you would like to proceed with that, ma'am?
Um,
Again, I can set the hearing date or I can waive that date for you.
which one means does any one of those options mean I get to go home possibly today?
So you will not, unfortunately, be able to go today unless you make bond. Waiving the hearing does move it a little faster, but again, I don't want you to do it just because of that. If you don't desire to have the hearing and you just would like to move it a little quicker, yes, ma'am, waiving the hearing does move it a little quicker.
All right, we can waive it.
All right, so I'm going to show here, ma'am, that you've requested I gone ahead and waive your preliminary hearing. Again, the theft by receiving has a bond of $1,500, the obstruction $2,500 for a total bond, ma'am, of $4,000. And as I say here, I also have that you have asked that I waive your preliminary hearing. And so the deputy should have a electronic signature for here for you to do shortly. And then once you do that, ma'am, I think that's all I have for you today. Do you have any questions for me, ma'am?
No, that's all.
All right. All right. Well, ma'am, good luck to you.
Thank you.
On the pad right there. Wow. It's on that pad right there. Please. This is for me. Just want to sit down until.
Give me one moment, ma'am. All right. And you are Miss Brown, is that correct?
Correct.
All right. So, Miss Brown, here we go. All right. So you were charged, ma'am, with one count of possession of marijuana less than 1 ounce and one count of violation of the Georgia Controlled Substances Act, which was a felony. Do you understand that, ma'am?
Yes.
Now, the violation of Georgia Controlled Substances Act as a felony, ma'am, carries a bond amount of $3,500. The misdemeanor possession of marijuana less than 1 ounce carries a bond of I'm sorry?
That was the sheriff's talking.
Oh, okay. The possession of less than 1 ounce carries a bond of $1,000, ma'am. So that brings your total bond to $4,500. Do you understand that, ma'am?
Yes.
Now, because you were charged with a felony, as I mentioned earlier, you have a automatic right to a preliminary hearing. I am going to go ahead and schedule your hearing for you. So unless you were to make bond, your next court date is going to be May 13th of 2026 at 8:30 a.m. via Zoom. Do you understand that? It's going to be May 13th. That's going to be at 8:30 a.m. and that's going to be via Zoom. Okay?
Okay.
Do you have
But I
any
can't
questions?
go ahead and burn out though today.
Say that one more time for me.
I can't, it's no question. I understand.
Were you were asking me a question about bonding out? I wanted to make sure I heard you.
Oh, yes, I was just making sure I can't just burn out today, even though my court date is May 13th.
Yes, ma'am. So if you happen to be able to make bond between now and the 13th, as I was saying before, you are absolutely allowed to go ahead and bond out by that time. It would just mean, as I mentioned, that you at that point would waive your right to your preliminary hearing. Okay.
Okay, I understand.
So I do have a couple other questions for you. I want to make sure that we go through your court-appointed counsel paperwork. Okay.
Okay.
All right. So Ms. Brown, I see here that you are married. Is that correct?
Correct.
And you have 2 children.
that live in my household. Or I think the question said that live in my household. I have 3 kids altogether.
Yes, ma'am. Are you currently working? Says
I
it.
do for Walmart,
Okay. And about how much are you making per month, ma'am?
about 11 to 1,200.
About how much? I couldn't hear you.
11 to 1,200 a month.
And then it says that your spouse is not working?
No, he does, he don't work.
Okay. All right, ma'am. So I am, based on that information, ma'am, I am going to go ahead and appoint you court-appointed counsel. And so you will have an attorney free of charge, ma'am, to be able to assist you on your case, okay?
Wonderful, okay,
All right, ma'am. Good luck to you.
thank you.
Thank you.
Ms. Brown.
What's up? And I believe you're Miss Freeman, is that correct?
Mhm.
Is that a yes? Ma'am?
Yes,
Okay.
you have to see.
All right, so Ms. Freeman, you were charged with 1 count of theft by taking as a misdemeanor and 1 count of obstruction as a misdemeanor. Now, I want to advise you, Ms. Freeman, now that we're back on track here, that I had a chance to review the warrants that were alleged against you. Now, at this point, Ms. Freeman, I am going to go ahead and dismiss your charges. But I want to be clear. Hold on. Let me be clear with you, ma'am. I want to be clear. I am dismissing them today. That doesn't necessarily mean that the officer won't make the corrections that he needs to make, or that the solicitor won't make those corrections and they decide to bring this case against you at a later time. However, as for today, strictly as for today, ma'am, you are going to be released later this afternoon, and then all of your property will be returned to you, okay? Ma'am, can you hear me?
Yes,
Yeah.
I appreciate it. What should I?
Okay. All right, ma'am. That's all I got for you.
Your Honor, quick question.
Yes, sir.
If you dismissing the case, do they still sign the bond conditions or what?
My understanding is that they don't need to sign anything at that point.
I need to do what?
Freeman.
I don't need to sign.
It's your key. I know, he didn't even look.
And are you Miss Gilliam?
Yes,
All right. How are you this morning, Miss Gilliam?
well, and yourself?
Doing well, ma'am. Doing well. Trying out a new system here, so we're all trying to make it work. Ms. Gilliam, you were charged with 1 count of misdemeanor battery family violence, ma'am. It does carry a bond amount of $3,500. Okay.
Okay.
You do have special conditions, ma'am, and they are going to be stay away from the alleged victim. That's a Mr. Derek Brooks. Do you understand that?
Absolutely.
And you are also to not possess any dangerous weapons and not be at any location that he is present. Do you understand that?
I do.
All right, so just to kind of go over what I was talking about before, just very briefly, you understand any contact whatsoever with this gentleman will be a violation of my bond and subject you to later charges, okay?
Okay.
All right. Now, lastly, ma'am, because you were charged with a misdemeanor, you have the right to a preliminary hearing, or you can waive that right to that preliminary hearing if you so choose. Would you like to have that preliminary hearing, ma'am, or would you like to waive your right to that hearing?
I'll have the hearing.
Do you need me to kind of go over it with you again, just to make sure you understand it?
Yes.
All right, so what I was saying before is a preliminary hearing is the hearing where you are present, the judge is present, and the police officer who arrests you is present as well. You all will make the decision about whether or not, or the judge will rather, there was enough evidence to move forward on your case. If the judge decides that there was, then the case will move on to the next stage, meaning it'll go to the prosecutor and to state court. However, if the judge believes that there was not enough evidence, he may decide to dismiss your case right then and there. Now, from time to time, there are people who will say, Judge, I don't want the hearing, just move it along because it moves a little quicker. So you have that option as well. You could tell me, Judge, I don't want the hearing. Please just go ahead and waive my right to the hearing. Okay, so it's really up to you how you would like to do that.
Waive my right to the hearing, but I can still bond out, so that's fine. I'll waive it.
Okay, so I am going to go ahead and show that you
Okay.
are requesting that you waive your right to that hearing, ma'am. And so because you are waiving your
Yes,
right
sir.
to that hearing, after you and I are done here, the deputies will have an electronic signature that they'll need to be able to get from you, okay? Can you hear me,
Thank
ma'am? Okay, one last thing.
Yes, sir. Thank you.
Okay, give me one last give me 2 seconds. I'll have you out of here. I've reviewed your court-appointed information here, and I see here, ma'am, that you said that you make about 800 a month. Is that correct?
Oh, I thought it was every 2 weeks. I checked every 2 weeks.
Okay, so it's about 1,600 a month?
Yes.
Okay. So based on that information, ma'am, you still do qualify for court-appointed counsel. I am going to go ahead and grant you counsel this morning free of charge, okay?
Thank you.
And so whether you bond out or not, make sure that they have your information here and your best known address, because that's the address that's going to be used by your attorney to try to contact you, okay?
Okay.
All right. Unless you have any questions for me, ma'am, you're free to go.
No, have a great Saturday.
All right, you too, ma'am.
Oh, yes.
All right, and are you Miss Hood?
Yes.
All right, Miss Hood, give me one moment here. All right, so Ms. Hood, you are charged here with 1 count of possession of marijuana less than 1 ounce as a misdemeanor, 1 count of possession of a weapon during the commission of a crime as a felony, and 1 count of possession of VGCSA as a felony, Schedule 1. The possession of a felony Schedule 1 drug carries a bond amount of $3,500. The possession of a weapon during the commission of a crime, ma'am, carries a bond amount of $8,000. The misdemeanor marijuana carries a bond amount of $1,000. Your total bond, ma'am, therefore, is $12,500. Do you understand that?
Yes, sir.
Okay. Now, you do not have any special conditions on your particular bond other than, ma'am, you are not to possess any dangerous weapons while you are out on bond. Do you understand that?
Yes, sir.
Now, because you are charged with felonies here, as I mentioned earlier, you have an automatic right to that preliminary hearing. And so the only way you will not get that hearing would be if you do not make your bond, if you make your bond and are released. Do you understand? All right, ma'am. So I've gone ahead and issued the warrants against you. Now, taking a look here at the paperwork that you provided this morning as it relates to court-appointed counsel, I see here that you are working. Is that correct? How much are you making per month, ma'am?
I make about 800. If I still have a job, it's about 800 a month.
Okay. And what sort of benefits are you receiving? I saw you check benefits.
Well,
Go ahead.
it's supposed to. It's
Okay.
300 a month.
Okay, got it. Okay. All right, ma'am. So based on what you provided in here to me, I am going to go ahead and give you court-appointed counsel this morning. So you will have an attorney free of charge to assist you, okay?
Okay.
All right, ma'am. Do you have any questions for me about anything?
No, sir.
All right, ma'am. So then that's all I have for you, Ms. Hood. Good luck to you this morning.
You're not waiving this. Nah.
No, she didn't. She was charged with a felony.
You didn't waive. She got some bond. She got some bond condition, though? Yeah, she just got any waivers. Oh, they didn't say bond conditions. They only signed extradition. Do they sign their bond conditions though, or no? It's just waivers? Waivers?
I think they do. It's only waiver. Yes, I think they still do sign on that bond if it has a signature form. It's just when they waive the preliminary hearing, and felonies do not waive.
Yeah, only waivers and extraditions, the only thing that is signed.
Okay. Yeah. I mean, it's new for everyone, but I know they've got to sign it for the misdemeanor, bond conditions. I don't have it on mine that they do, and then extradition, yes, of course they do. All right, are you Miss James?
Yes, sir.
Miss James, let me bring your information up here. So, Miss James, you are charged with 1 count of misdemeanor battery, ma'am. That carries a bond amount of $3,500. You do, ma'am, also have special conditions. You are to stay away from the alleged victim, a Gabby Hood Miller, and also from the address of 830 Highway 138 Southeast in Jonesboro. You are also not to possess any dangerous weapons, as also to stay away from any location where this person, Miss Hood Miller, may be found. Do you understand that, ma'am?
Yes, sir.
Do you have any questions about the bond conditions I've just provided to you?
No, sir.
Now, because you are charged with misdemeanors, ma'am, you have the right to that preliminary hearing that I mentioned earlier, or you can waive your right to the hearing. What would you like to do?
I'm just do the bond and get the bond paid.
Okay, so I need you to answer my question though. Are you wanting me therefore then to waive your right to the hearing?
From my understanding, if I pay the bond, it's automatically waived, right?
Yes.
So, yeah.
Okay, so I am gonna go ahead then, ma'am, and show here that you are asking that I waive your right to that preliminary hearing. And once you and I are done here this morning, the deputies will have an electronic signature that they will need to get from you, okay?
All right.
So looking here this morning, ma'am, I want to go over these documents with you with respect to court-appointed counsel. Let me ask you, are you working right now?
Not currently.
Okay. And I see here that you are single, is that correct?
I have a boyfriend, but that option wasn't on paper.
Okay. And so the only support, I see here about $300. So, ma'am, based on what you provided here to me this morning, you do qualify for a court-appointed counsel. So I am going to go ahead and appoint you counsel free of charge for you, okay?
All right.
All right, ma'am. Do you have any questions about anything for me?
That's all. You have a great day and thank you.
Yes, ma'am, Ms. James, and you enjoy the rest of your day as well.
Well, every day.
All right, the last female should be Miss Whitby.
You just sign what you made. Yes, yes.
Can't hear you. From South.
Ma'am?
No, I can't hear you.
I said, are you Miss Whitby?
Yes, sir.
Okay. Ms. Whitby, you were charged with 1 count of cruelty to children in the 2nd degree as a felony, 1 count of cruelty to children in the 2nd degree as a felony for a total of 2 counts. And then you were also charged with 3 counts of misdemeanor battery. The first count of felony cruelty to children carries a bond amount of $10,000. The second count of cruelty to children as a felony carries a bond amount of $10,000. The counts of battery, the first $3,500, the second $3,500, and then the third is $3,500 as well. Excuse me. That brings your total bond, ma'am, to $30,500. Do you understand that?
How much is that with the bonded company? How
Say that
much
one
is
more
that
time.
altogether? Like if I go through a bonded company?
You
How
said
much is that if I go through like a bonded company?
Yeah, sure. No problem. We can go through that. If you were to go through a bonding company, ma'am, then as I said before, it would be anywhere from 12 to 15% of what that bond is. Roughly, you'd be looking at about $4,200 that you'd be responsible for yourself out of pocket. And then, as I said, the remainder of that would be the responsibility of the bonding company. But remember, the difference is, unlike a cash bond, you do not get that money back, okay? Do you hear me?
Yeah.
Okay, do you have any questions about that portion?
And how much was how much was it altogether?
$30,500.
$30,500.
Yes, ma'am. Now, let me be clear too, you've got special conditions on your bond. That means, as I explained before, I'm going to tell you some things that you can and cannot do. While you are on bond, that means until your case is closed, you are to have no contact with minor children, Josiah Oden, Sincere Grover, and then the other party, I believe, who was an adult alleged victim, Jasmine Grover. Do you understand that?
Okay.
Also, you are not to return to the address of 1951 Southampton Road. Now, let me ask you this, ma'am. These children, the minor children, and I guess, is Miss Grover your adult child, or who is Miss Grover?
Miss Jasmine Grover is my significant other. We was together for 7 years, and those are her 2 kids.
These
and
are her kids.
And those are and that's my house that they're staying in. That's
okay.
I was actually trying to leave. I had a TPO put out.
Okay, remember, hold on, man. Remember, you don't want to get into
I know.
of what's going on. I just wanted to make sure. Okay, as of right now, ma'am, unfortunately, because of the way that these charges are, you will not be able to return to that property while they are there or to have contact with them. Now, but let me be clear. If you make this bond, you can return. You can schedule an appointment with the sheriff's office. They can escort you out there to get any items that belong to you. But once they leave and you've gotten everything you need, then you have to leave, okay?
Okay, you said my bond was 33,500?
Yes, ma'am, that's correct.
And it's 15% at the bonding place, correct?
12 to 15%, yes, ma'am.
Okay.
All right, thank you, ma'am.
All right.
All right, deputies, if you will give me one moment, please.
Ask me that. Huh? He didn't even ask me.
Your Honor,
Yeah.
did she waive?
She did not, she's charged with felonies. Give me one moment. Also.
Alright. First man, the rest of y'all sit down. First.
Yeah, no.
What's your last name, sir?
Burden.
Burden.
Burden. Yeah.
What's that? Where's the money?
I think.
Where's money?
Maybe you said that. You said thing for the whole time, you just.
So we don't need to move the house break. 30 minutes break.
Is it?
That's it.
Yeah.
I would do it. So the transport, I would do it. Before that, I'm going to the County.
So when do you leave the break there?
You to go to the 30-minute break, that's it. Then you can go. That is, that's one.
We can always-
No.
What time do they get off? What time do they get off?
30. 7 to 7.
Yeah.
Okay, sir, sorry about that. Can you hear me now?
Yes,
Oh, sir, can you hear me?
Yes.
Okay. And are you Mr. Burden?
Yes.
Okay. Mr. Burden, you were charged here with 1 count of affray as a misdemeanor and 1 count of battery as a misdemeanor. The affray carries a bond amount of $1,500. The battery carries a bond amount, sir, of $2,500. And so your total bond here this morning, sir, is $4,000. Do you understand that?
Say 4?
4,000, yes, sir.
Okay.
Okay. You do have a special condition, sir. That one special condition being that you are to stay away from the alleged victim, who I know is also in custody upon your release. And the name of that gentleman is Mr. Anthony Real. Do you understand that?
Yes.
Okay, now, sir, because you are charged with a misdemeanor, you have the right to a preliminary hearing, or you have the right to waive that preliminary hearing. Would you like to have that hearing or waive it, sir?
I keep it.
Okay, so I am showing that you would like to retain your preliminary hearing or your right to that preliminary hearing. And so I'm going to give you your new court date. If you do not make your bond, which is the only way that you'll get the hearing, sir, your new court date is going to be May 12th, and that's going to be at 8:30 a.m., and that's going to be via Zoom. Again, if you do not make bond this morning, your next hearing date will be May 12th. It'll be at 8:30 a.m., and that will be via Zoom, okay?
Okay.
All right, any questions that I can answer for you this morning, sir?
No, you said my bond was 4,000, right?
Yes, sir. It's 2,500 on the first, 500 on the first, 1,500 on the second count for a total bond of $4,000. Okay.
With the bond cover, that's like what?
You'd be looking about 12 to 15%. Figured about a little over $500.
Okay.
All right. Well, you don't have anything else, Mr. Burton. The last thing I will tell you, sir, is I did have a chance to review the information you provided. Just one question I want to ask. Are you currently working, sir?
I was, but the victim, that's who I was working for. So
Okay, at that skybox?
yeah.
Um,
So I might not have it. No, I'm not even gonna say I might not. That job is probably gone. So
but he does not own the skybox, does he?
he say it does, but I'm really not sure.
So here's what the reason I want to clarify that. So I'm going to let you return there if you may have that job, but I am going to prevent him from returning since he was the aggressor. So, if there's an opportunity for you to inquire about whether that job will be yours after the fact, you will have that opportunity if you make bond, okay? Do you understand? Sir?
Yes. Yes.
Okay. Okay. All right. So I've gone ahead. I'm appointing you court-appointed attorney this morning, Mr. Burton. Again, it's $4,000 is the bond. That should be everything, sir. Good luck to you. I think I've lost you guys on your end. All right.
Thank you.
Okay. All right. Next up should be Colbert.
Yeah.
All right. Are you Mr. Colbert? Are you Mr. Colbert? Is that my connection or theirs? Mr. Colbert, can you hear me?
Yes, sir.
Okay. You are charged with one count of unlawful conduct during a 911 call, sir. That is a misdemeanor. Because it is a misdemeanor, you are charged with a bonding amount of $1,500, sir. You have the right to a preliminary hearing, or you have the right.
I'm charged with? What you say I'm charged with?
Lawful conduct during a 911 call, sir.
What's that?
Essentially, you were making calls to 911 that you were not supposed to.
All right.
You're not supposed to make call, and I don't need you to respond. So don't admit or say you did or didn't do it. But they are alleging, the police, that you made illegal contact to 911 when you're not supposed to. So my question to you, sir, you're charged with a misdemeanor. Would you like to waive your preliminary hearing for this charge, or would you like me to keep the hearing date? Mr. Colbert?
The judge though. Fuck that judge, man. Come on, man.
Mr. Colbert?
That man don't know what the fuck he talking. I got killed last night, man.
All right, deputies, I'm gonna go ahead.
Killed last night.
I'm gonna go ahead and assign him a preliminary hearing date. It's gonna be May 12th at 8:30 a.m. It's gonna be via Zoom if he doesn't bond out.
I ain't gonna bond out. I ain't got nobody.
Good luck to you, sir. You can take him, deputy. He's got a bond, so he's not waiving.
Okay, thank you. So. Good.
All right, give me 1 second, sir.
Oh, put him in, what, 9, take the dude out of 9. Is somebody in 9?
Yeah.
No, take the dude out of 9. Yeah, not keep the stuff on. Yeah, okay.
All right, are you Mr. Coleman?
Yes.
He put him in, sit, he got there, he gonna last.
You want that?
All right, Mr. Coleman, you were charged with one count of misdemeanor, giving a false name, date of birth, and then also one count of driving with a suspended license. Do you understand that, sir?
Yes.
The giving a false name carries a bond amount of $2,500. The driving with suspended license, sir, carries a bond amount of $1,000. And so your total bond, sir, is $3,500. Do you understand that?
Okay.
Okay. Now, because you were charged with misdemeanor, sir, you have the right to a preliminary hearing, or you can waive that right to the preliminary hearing. Which would you like to do? Would you like to have your preliminary hearing, sir, or waive that right?
Wait.
All right, sir. So I am showing that you are requesting to waive your right to a preliminary hearing. But once you and I are done this morning, the deputies will have an electronic signature that they will need to get from you. But before we're done,
So signature bond?
no, sir, no signature bond deduction, sir. Mr. Coleman, let me ask you, are you working right now, sir?
Yes.
How much are you earning per month?
Oh no. Can't think back of my head.
Where do you work?
Nestle Purina.
How many hours a week do you work?
Yes, dog.
I'm sorry?
Say that again.
How many hours a week do you work?
Like 70. More than that.
All right, sir. So I'm going to show that you do not qualify at present for court appointed counsel. That may change, but as of right now, you have to get your own attorney if you need one for your case. Do you understand that?
Yes.
All right, Mr. Coleman, good luck to you.
Oh,
Thank
how much my bond would be with a bond up?
3,500, about 400. All right, thank you, sir. Next up should be Day.
Signature bond.
Yeah, no.
Free, you free? Just 1 second,
Christopher Day should be next, I believe. Oh, I'm sorry, I apologize. Yes. Is there,
We go to last.
doing Day last? Okay.
No, Gates last. You said Gates, right?
No, I was at Day, D-A-Y.
Oh, he's not active.
Oh, okay, I see. Deputy, before we move on, did we do Kimberly Freeman?
Yeah, she was the second one we did.
Okay,
That's the one that got dismissed.
Okay, that's what it was. All right, so who do you have next on your end?
Hardy.
Who's that? Hardy? What's your name?
Yo, Hardy.
Yeah.
Hardy.
Give me 1 second. Give me 1 second, sir.
I'm gonna sit down and stay right here.
And right there.
Yeah.
They probably on the radio.
He was young too. Is that? He said. Oh, it's just two.
What he said, we can't be.
He said it's y'all gotta do.
We gotta get them the people on hospital details like in the line. Or 30-minute like.
I mean,
I don't know.
All right, sir, can you hear me?
Yes, sir.
And your name, sir?
Cleo Hardy. You see me?
Yes, sir. I'm just pulling up your information. Give me one moment.
Oh. Oh, no, I asked me. I thought maybe I was not speaking. What you say, see? Fine.
No, he's right here.
Mr. Hardy, you are charged with 1 count of misdemeanor disorderly conduct, 1 count of simple assault, and you were initially charged with elder abuse as a felony, sir. Your bond amount as to the disorderly conduct is $1,500. As to the simple assault, your bond amount is $2,500 for a total bond of $4,000. As to the elderly abuse as a felony, sir, I have reviewed the information there and made the decision to dismiss that charge against you. Now, it doesn't mean that it may not come back at a later date, but as of today, sir, you will not have that charge pending against you. Do you understand that?
Yes, sir. Thank you.
Now, Mr. Hardy, you do have special conditions. Those conditions are that you are to stay away from the alleged victim, that elderly gentleman, Mr. Francis, until this case is closed. Do you understand that?
Yes, sir.
Now, because you were charged with misdemeanors here, you do have the right to waive your preliminary hearing or to have it if you so choose. Would you like to waive your hearing or have it, sir?
Can I ask you a question?
Yes, sir.
What is the preliminary here, so I know?
Yes, sir. Again, the preliminary hearing is a hearing where you're present, the judge is present, and the officer is present to review the evidence that the officers have obtained against you in your case. It's not your trial, but at the preliminary hearing stage, if the judge determines that there's enough evidence, he can dismiss your case. Okay?
The officer's not here.
Huh?
He's not here.
No, it doesn't happen today. It's not today. It'll be a
Oh,
month.
it's not today. Oh, May 12th.
Yes. Or you can tell me, Judge, I don't want to wait around for that preliminary hearing. Just go ahead, send mine on up to the prosecutor, and it'll move it a little quicker. So it's up to you. You can either I can set that date, and if you don't bond out, you'll get the hearing, or you can waive it and go straight to the prosecutor.
So I can wait a hearing.
Yep, or I can set the
Go
date for you.
straight to court. So if I take the hearing, then I gotta show back up down here on May 12th. Like
No, sir, you will only get that hearing if you don't bond out.
Oh, and how much the bond? $400.
So your total is $4,000, so you're looking at about $500, sir.
Okay, no. I should be able to find somebody getting $500. I get out of here.
And so what would you like me to do about the, you want to waive it? All right, so I'm showing that you are asking that I waive your right to that preliminary hearing, sir?
Well, let me ask you that. So if I take the here, I have to show, so I said,
okay, so let's do this. Here's what we're gonna do, Mr. Hardy, because I have people behind you, sir. I'm gonna go ahead, listen to me. I'm gonna set that preliminary hearing date. All right, the preliminary hearing is May 12th, okay? It's gonna be at 8:30 a.m. and it's gonna be via Zoom. Mr. Hardy, if you make bond, that hearing will not happen. Do you understand that?
Okay, yeah, I like that.
Okay, only if you make bond, that hearing will not happen. Do you understand?
Yes.
Okay, otherwise, that hearing will happen on May 12th at 8:30 a.m. via Zoom. Now, I see here that you have 3 children. Are you currently working, Mr. Hardy?
I'm a stay-at-home dad.
Okay, do you live with anyone that provides you support, financial support?
My dad gives me money.
Okay. Where do are you living at his residence?
No, I'm living in my residence.
Okay. Do you rent or own?
I'm kind of renting from my dad.
Okay.
Other than this, I've been kind of lucky.
All right, sir. So I am going to go ahead and approve a court-appointed counsel for you, sir. So you will get an attorney for your charge. Okay, Mr. Hardy?
Yes, sir. Thank you.
All right. Thank you.
That's it?
Yes, sir.
Well,
You good? Go my door. Right here? Yeah, that's.
well,
Oh, that's it. To the end part.
Wait.
Before.
Okay.
And you are, sir?
Naftali Yildiz-Gabay.
I can barely hear you, sir. Can you speak up for me?
Naftali Yildiz-Gabay, my name.
Okay.
Goodbye.
Um,
We're not goodbyes. Like that. Oh, man, they're not so bad. They don't forgive us for all.
All right, so Mr. Goodbye, you are charged with 1 count of disorderly conduct, sir. Now, I want to be clear on what I'm about to tell you, sir. I've reviewed the information that was provided to me. I am going to go ahead and dismiss your case this morning. So you're going to be allowed to go home today. But let me be clear, I'm dismissing it because there is some information that the police officer who arrested you forgot to provide for me. If that changes, they could bring this back against you, okay? But right now, you're gonna go home today, okay?
Okay, okay.
Do you have any questions for me, sir?
No.
All right, so you take care of yourself, sir.
Yeah.
All right, thank you.
Come on, this way, this way.
Come on, go
And your name, sir?
Maxwell Jacques.
All right, so Mr. Jacques, you were charged here with 1 count of running a red light as a misdemeanor, 1 count of DUI, and 1 count of child endangerment by DUI. The red light violation carries a bond of $500. The DUI carries a bond of $4,000. The child endangerment by DUI carries a bond amount of $4,000 for a total bond of $8,500. Do you understand that, sir?
Yes, sir.
You do have a special condition, sir, and that is that while you are on bond, that you are not to consume any alcohol. Do you understand that?
Yes, sir.
Now, reviewing all of the information you provided, sir, you are charged with a misdemeanor. Now, because you are charged with a misdemeanor, that means you have the right to a preliminary hearing, or you can waive that right to preliminary hearing. Do you understand that?
Yes, sir.
What would you like to do this morning, sir? Would you like to have that hearing or waive that hearing?
Wait.
All right, sir, so I am showing that you are requesting me to waive your preliminary hearing. So I am going to show that here this morning. Once you and I are done, the deputies will have an electronic signature that they will need to get from you, okay?
Yes, sir.
Now, I see here, it says here that you're making about $700 a week. Is that also correct?
Add a few, lose a few. Around there much. Yes, sir.
Okay. Based on that, sir, and the information then that you've provided thus far, I am going to find that you do not qualify for a court-appointed counsel. So if you will need court-appointed counsel here, sir, for your case, you will have to hire your own lawyer. Do you understand that?
Yes, sir.
All right. Mr. Jacques, find that you waived. And, all right, sir, that's all I have for you. Good luck to you.
Okay.
Now, you Mr. Lanham?
Yes, sir.
All right, sir. Mr. Lanham, I have here that you are charged with 1 count of felony escape, sir. The bond amount, sir, for your particular charge is $10,000. Okay, you do not have any special conditions, Mr. Lanham. However, I need you to understand that because you are charged with a felony, you do have a preliminary hearing court date set for you. So if you don't make your bond on this, then your next court date, sir, is going to be May 13th at 8:30 a.m. and that's going to be via Zoom. Again, if you do not make bond on this, your next court date will be May 13th, and that's going to be at 8:30 a.m. and that will be via Zoom. Do you understand that, sir?
Sir.
Do you have any questions of me about anything?
No, sir.
I'm sorry?
No, sir.
All right, sir, then that's all I have for you. Good luck to you.
Three y'all in there? Yeah, y'all come on out. Four, yeah, all pay right now. What's the last name, sir? Russell. Smith.
Are you Mr. Nicholas
Nichols, yes, sir.
or Nichols? Excuse me. All right, so Mr. Nichols, you were charged with one count of disorderly conduct as a misdemeanor, one count of simple assault. The disorderly conduct carries a bond amount of $1,500. The simple assault carries a bond amount of $2,500. So your total bond amount, sir, is $4,000. You do have a special condition. That is to stay away from the alleged victim in this matter, a Mr. Gary Francis. Do you understand that, sir?
Yes, sir.
Do you have any questions about anything thus far?
So I'm gonna have to pay 10% of that, right?
12 to 15%, sir.
Okay.
So you'd be looking at on 4,000, roughly about five grand to 5,500. Oh, excuse me, 550. Let me ask you this: are you currently working?
No, sir.
All right. So based on that, sir, I am going to go ahead and appoint you a court-appointed counsel. So you will have counsel free of charge. Okay.
Okay.
Now, as to your preliminary hearing, sir, would you like to have your hearing or waive that right to the hearing?
Hold on, can I ask you a question?
Yes, sir.
So waiving it mean like I could.
Waive it simply means it'll move your case a little faster and I'll send it to the prosecutor.
Okay,
If you
yeah, I
don't-
would like to waive it.
Okay. All right, sir, then I am showing that you are requesting that I waive your right to that preliminary hearing. So I'm going to go ahead, place that here. The deputies will have a electronic signature that they will need to get from you. Once they get that signature from you, then that's all I'll have for you this morning, okay?
Okay, thank you, sir.
All right, thank you.
Sign right here. Next man, you good to go. Sign your name. Sorry for that shit. She didn't know. She didn't know.
Are you Mr. Real?
Yes, sir. Yeah.
Mr. Real, you are charged with two misdemeanors here, one count of affray and one count of battery. And so I'm going to go through these charges with you, and you're also going to have special conditions that we're going to talk about as well, okay? All right, Mr. Real? Can you hear me, sir?
Yes, I can.
Okay. As to the bond amount, the affray carries a bond amount of $2,500. The battery carries a bond amount of $2,500. Your total bond, sir, is going to be $5,000. You do have special conditions, sir, and they are to stay away from the other party involved, the alleged victim, Diaz Burden, Burden, and also to stay away from the Skybox, 2180 Mount Zion Parkway. Do you understand that?
Yeah, but it can't be the Skybox because I own it.
So, sir, at this point, unless that decision is made by a later judge, I understand the allegation. The other gentleman, Mr. Burden, told me that, but as of right now, that's my decision.
But sir,
Okay.
I'm operating.
Mr. It's not up for discussion.
Okay.
You know, you'll have an attorney and they can request that change. Let me ask you this, because you are charged with misdemeanors here, you have the right to waive your preliminary hearing, or I can set that hearing date for you. Would you like to waive your hearing, or would you like me to set that hearing date?
Wait.
All right, sir, I am showing that you are asking me to waive that hearing date.
Yes.
So once we are done here this morning, with everything that we have to do, they will have an electronic signature that the deputies will have to get from you, okay?
Yes.
Now, I understand that you said that you own the Skybox. Based on the information here that you provided, sir, I am going to go ahead and advise you that you do not qualify for a court-appointed counsel, And so what that means is you will have to obtain your own attorney. Do you understand that?
Yes, I do.
All right, any questions, Mr. Rio?
I just have one about the skybox. I didn't understand that part of it. If that's my.
So at this, and let me say this, at this point, sir, because you are the aggressor, I understand that you own it, or there's a belief that you own it, but I'm gonna say that you are not allowed to return at this point. Now, ultimately, your attorney may decide that that's gonna change. They'll show evidence to a later judge that he owns it. He should have the right to go back to his business, and that's fine. But as of today, you will not be allowed by my order to return. Good luck to you, sir.
Okay. Okay, thank you.
Thank you.
Am I finished?
Yeah, come around. You know, gonna sound, but then you already.
It should be, I believe, Cornelius Roberts. Are you Mr. Roberts?
I'm Russell. Courtney Russell.
Robert is not active.
Okay. All right, Courtney Russell.
You and your dorms. Dorm. Tell me the dorms that, you can say that.
All right, so Mr. Russell, you were charged with one kind of misdemeanor violation of seatbelt law, just simply saying that you didn't have a seatbelt on at the time. Then the second charge here is violation of the Georgia Controlled Substances Act. Do you understand that? Mr. Russell?
No,
Mr. Russell?
Yeah, you can hear me?
Yes, sir, I can hear you now. So did you hear anything that I was saying before?
Yeah, I heard you. I was asking
Okay,
you to explain the charge.
Yes, that's what I was trying to do. So
Okay.
count one was a violation of the seatbelt law. It's a $500 bond amount, okay? Did you get that part?
Right, yes, I did.
The second charge is the violation of the Georgia Controlled Substances Act, meaning that the police are alleging that at the time that you were pulled over, that you were in the possession of an illegal substance here in the state of Georgia, and the bond amount for that is $3,500. Do you hear that?
Yes.
Okay. The total bond amount then is $4,000. Do you understand that?
Yes.
Okay. Now, secondly, you do have I've given you a bond. At this point, the only special condition that you have, sir, is that you are not to possess any intoxicating liquor or drug while you are in custody. So that means you may be randomly screened for drugs or alcohol to be on your possession. If you are found to be in possession of either in your body or on your person, that you can violate this bond. Do you understand that?
Could you say that one more time?
Not to have any drugs or alcohol while you're on bond.
Okay.
Okay. Now, you are charged with a felony, sir. Because you are charged with a felony, the drugs, that means if you don't make the bond that I just gave you, your next court date will be at May 13th at 8:30 a.m. and that will be via Zoom, Mr. Russell. Again, that'll be May 13th. That'll be at 8:30 a.m. and that will be via Zoom. Do you understand that?
Yes, I do.
Do you have any questions thus far about anything that we've talked about?
What's the percentage I had to pay? Like,
4,000, you're looking at about 500 to 550.
okay, cool.
Okay.
Okay, well, thank you.
Yes, sir. Now, I'm showing here that you are not working right now. Is that correct?
No.
Okay. So based on that, Mr. Russell, I am going to go ahead and appoint you court-appointed counsel. So you will have an attorney free of charge to be able to assist you on your case. Do you understand that?
All right.
All right, sir. And that's all I have for you. Good luck to you.
All right, thank you.
Thank you. All right. And your name, sir?
Christopher Smith.
Okay. All right, Mr. Smith, you are charged with one count of criminal trespass damage to property, sir. Your bond amount is $2,500. Okay. Do you understand that, sir?
Yes, sir.
All right, give me one moment here. I just want to make sure one thing on your matter here. So they've got, Mr. Smith, were you arrested on two separate cases? Do you know? Mr. Smith?
This,
Yeah,
yes,
it
I
looks like
just
yeah, it looks like you've got two separate cases going. Did you know
got
that?
arrested, well, I know, they say I had
You had an old case?
a warrant for something in, yes, sir.
Okay, so let's do it this way. The first one is the one we just talked about. So that's a misdemeanor criminal trespass, damage to property. Now that
Okay.
is back from, it looks like it says June 11th, and that's from 2025. That was an outstanding warrant that you had, looks like you had never been picked up on, okay? Can you hear me, sir? All right, so on that one,
Right.
your bond amount,
Yes, sir.
I may have been talking over you. Say that one more time. What were you saying?
No, I said, yes, sir. I heard everything you said.
Okay, so your bond amount on that one, sir, is gonna be $2,500 on the old charge, okay?
Okay.
Now, for that one, because that is a misdemeanor, sir, you have the right to a preliminary hearing, or you have the right to waive that preliminary hearing. Do you understand that?
Yes, sir.
Now, for the misdemeanor case, what would you like to do? Have the hearing or waive it?
Yeah, look, like, if I say, had a hearing, that mean like later, if I'm still in here, didn't make bond, I can have a hearing, right?
Correct. That's correct.
Okay, no, I don't want to waive the hearing.
All right, so because you are charged with, on that other case, felonies, I'm gonna put this on the same date as your other case, okay?
Okay,
So you're gonna have both of your cases are gonna be heard on May 13th at 8:30 a.m. via Zoom, okay?
okay.
Now, because of it looks like you're not working right now. Is that correct, Mr. Smith? Is that correct, sir? Okay. So I am gonna go ahead and appoint you court-appointed counsel for your cases, okay? So you'll get an attorney free of charge to be able to help you, okay?
Okay, thank you.
All right, so that's the first case, the one with the criminal damage to property that happened back in June of last year. We've gone ahead, we've done that one, the bond amount, 2,500. I'm giving you an attorney, so you will have all that for you, okay?
Yes, sir.
All right, so now let's talk about the second case that you got here. The second case is the one that you were most recently taken into custody for. In that one, you are charged with a felony count of possession of a controlled substance and then possession of marijuana less than 1 ounce. Do you understand that?
Yes, sir.
Okay, now the bond amount for that one, that first count, the felony count is 3,500. Okay.
Okay. Yes, sir.
The bond amount on the second count, the marijuana, is $1,000. Do you understand that?
Yes, sir.
Now, so your total bond amount for that one is the 3,500 plus 1,000, which is 4,500. Do you understand?
Yes, sir.
All right. Now, on that one, again, you do not have any special conditions for your bond. On this one, I've also gone ahead. I'm going to appoint you court-appointed counsel as well on this one. Your next court date is going to be that preliminary hearing. So it's going to be that same date. It's going to be at May 13th. It's going to be at 8:30 a.m. and it's going to be via Zoom. Do you understand that?
Yes, sir.
All right. So you got two cases. One, 4,500. The second, 2,500. The preliminary hearing date that you wanted for both is going to be May 13th at 8:30 a.m. via Zoom. And you will have an attorney for both cases. Okay.
Yes, sir.
All right, Mr. Smith, that's all I've got for you. Good luck to you, sir.
Thank you. Thank you very much.
Thank you. And you are, sir?
Joshua Opoku-Techi.
I'm sorry, say it one more time.
Joshua Opoku-Techi.
Okay. All right, so deputies, this is the fugitive. I just want to make sure it was him. Do you have Wiggins and Worrell there with you?
Wiggins and who else?
Worrell, those are the other two on my list.
Okay, I got him. I got all three of them. I know
Yeah,
that
can we
scene.
hold for Mr. Joshua and then we'll do those two first?
You ain't no future? We got 2 or 3.
I should have two. I should have Wiggins and Worrell. I have only one fugitive. That's Mr. Joshua, the one that was just there. Wiggins and Worrell just have normal charges.
All right, here you go, Joshua.
No. And what's your name, sir?
I'm Wiggins.
Okay. All right, so here we go. Let's bring you up, Mr. Wiggins. Okay. Okay. All right, so Mr. Wiggins, you are charged here with 1 count of possession of marijuana less than 1 ounce, 1 count of possession of a Schedule I controlled substance, and 1 count of possession of a firearm during the commission of a crime, that being in the possession of the alleged drugs, okay? Do you understand that, sir?
Excuse me?
Do you understand what you are charged with?
That, it was breaking up.
Okay, yeah, no problem. We can go over it again. You were charged with
Yes,
1
sir.
count. Can you hear me? Mr. Wiggins, can you hear me? You're on mute. You're on mute. Take it off mute. There you go. Can you hear me now?
Yes, sir. I can hear you now.
Okay. I want to make sure we go everything so you hear me. You were charged with 3 counts. The first was possession of marijuana in less than 1 ounce. The second count was possession of a felony drug. The third count is possession of a firearm during the commission of a crime, okay?
Yes, sir.
Okay. Now, the possession of marijuana less than 1 ounce, it carries a bond amount, sir, of $1,000, okay?
Okay.
The possession of a felony drugs carries a bond amount of $3,500. Do you understand that? Okay.
Okay. No, well, never mind.
The firearm charge carries a bond amount of $8,000. And so your total bond right now, sir, is $12,500. So I'm not saying whether you agree that this is your stuff or not. I just need you to understand what your bond is. Do you understand that?
Yes, sir. So $12,500.
$12,500 is the bond. Okay? Yes or no? Do you understand?
Yes, sir.
Okay. Now, because you are charged with felony, sir, you have an automatic right to a bond hearing. Preliminary hearing. So if you don't make your bond in the next 30 days, your next court date is going to be May 13th at 8:30 a.m. and that will be via Zoom. Again, that's May 13th. That's 8:30 a.m. and that will be via Zoom. Do you understand that, sir?
Yes, sir.
Now, looking at the information you provided, are you currently working, sir?
Yeah.
Where do you work?
I work for Bird.
Okay. And how much do you make per week?
It depends on the routes I do. So it's no set amount.
Okay. Just give me an average how much you bring home per week.
500 to 800.
Okay. So based on the information you provided, sir, you do not qualify for a court-appointed attorney. So that means if you want an attorney for your case here, you will have to hire your own, okay?
Okay,
All right, sir, that's all I have for you.
okay, all right.
All right. Good luck to you, sir. Is it, and I believe, are you Mr. Worrell? Is that correct?
Yes, sir.
Okay, give me one moment here, Mr.
Yes,
Worrell.
sir.
All right, give me 1 second here, Mr. Worrell.
Oh, hold on. Y'all two together, both y'all three. I'm accusing. What's my name? Warrell? Yeah, he said.
Worrell is not. He is not.
Who the other person you told us is?
It's only one. It's Joshua Takei.
Boy, okay.
Yeah, it's just him.
I swear y'all thought he said three.
Nope. All right, so Mr. Wiggins, I just wanted to go over some information here to make sure we've got everything correct here for you.
Mr. Warrell?
Excuse me, Mr. Worrell, my apologies.
Thank you, sir.
How long took left, go get on the elevator?
Just going through all your documents here.
I was trying to figure it out too.
So, okay, here it is. So they've got you charged, Mr. Wiggins, with 1 count of theft by taking. This looks to be a fairly old case, though.
Yes, sir. Oh, can I tell you something?
I'm sorry, say that again?
May I tell you something?
No, sir, you don't want to, we don't want to talk about.
No, not about the case. I just wanted to tell you something.
Now, here's what I'll say. I will hear from you,
Mhm.
but please understand that you're taking the risk of,
Yeah, jeopardize myself. Yeah, nah.
Yes.
Nah, I was actually going to pay some tickets, and that's how I found out I had a warrant in Clay County, paying for my license. And I got locked up at the courthouse.
Okay. So let me say this. How long have you been in custody?
I left Newton County. I got locked up in Newton County. I've been in there 2 days, and then they came and transferred me here. So this is my second day here.
This is your first day before a judge?
Yes, sir. I don't get in no trouble.
So, Mr. Worrell, I hate to do this, but they did not provide, I don't want to release you because they didn't provide the warrant so that I could review it here. So I'll be honest, I see what you are charged with. However, I do not see, I'm not able to review it to see the validity of the charges at this point.
May I say one more thing to you?
Yes, sir.
It was a shock to me. It was actually a shock to me that I had a warrant because I haven't been in Clay County in years. So when I read that paper that was provided to me with the theft by state, it was a shock to me because I don't even know who the co-defendant is. So just being
so
honest.
I can't really comment on that, sir, the validity of it. Like, that's the problem. So because I can't see that information, I can't really comment on, whether this has any validity to it or whether it should be dismissed altogether. So here's what I'm going to do. I'm not going to let it linger. I'm going to go ahead and just continue this for today only, to give them 1 day to get this warrant in here. If they don't get it in here by tomorrow, then they're going to go ahead and release you. And then they'll have the police will have to figure that out. Okay.
Yes, sir. I appreciate it.
Yes, sir. All right. So deputies, I want to make sure whom we have left. You're good to go, sir. You continue.
Thank you.
Did we have a Christian Gates or what happened with him?
Yeah, that's what we're going last. I went before that. You said.
Okay, I just wanted to make sure that's why. So I've got Christian Gates and then the fugitive. Mr. Gates, you can come on up.
I haven't been on pro. I don't know. We're doing Gates last, Shauna.
Okay, do you want to do Joshua first then?
Yes, sir.
Okay. Are you Mr. Joshua?
Yes, sir.
Okay.
All
right, so Mr. Joshua, has anyone explained to you why you are here yet?
No, sir.
Okay, so you are what we call a fugitive from justice. That's why I wanted to do you last, so we'd have a moment to just kind of talk, and it wouldn't be confusing with what's going on with everyone else. What that means is, sir, is you are not charged with anything here out of Clayton County. Instead, Mr. Joshua, you have charges from another state. And so I'm just going to let you know what those are. They may, I can't, tell you whether they're valid, tell you whether it's right, tell you whether it's wrong. I can only tell you what the charge is. Do you understand that?
Yes, sir.
So it looks like they are saying back on June 13th of 2025 that you were alleged and charged with 3 counts of credit card fraud out of the state of Virginia. Do you understand that?
Yes, sir.
And again, I don't want you to say anything. That way you're not commenting on whether this is true or not. I just need you to understand that that's why you got picked up, okay?
Okay, sir.
Now, that's why you got picked up. But we got some things to discuss here. As far as how you want to move going forward. We can do a couple of things. Because you have these charges, sir, you have the right to have a hearing here in the state of Georgia and Clayton County. Now, the hearing is not about your charges. The hearing is just about the procedure that was used by the police officers to get you picked up. Now, the police officers out of Virginia have up to 60 days if you want that hearing. Excuse me. They have up to 60 days to come get you and take you back to Virginia. Or you can tell me, not 60 days, 30 days. So they've got up to 30 days to come get you and you can deal with it back in Virginia. Or the alternative that I mentioned to you earlier, you can have that hearing and you'll stay here in the county and then we will set that hearing date. Now, as I was saying before, they have a time frame to get that hearing done and you have that up to 90 days to get the hearing or you are let go. So just to clarify because that's a lot to take in. You've got 3 charges pending out of Virginia. You got an option. Option 1 is, judge, just send me back. I'll deal with it in Virginia. If you want to do that, they've got 30 days to come get you or we let you go. If you say, judge, I want my hearing here to make sure that the Virginia police officers did everything correct. If you want that hearing, then they get 90 days to set that hearing here in Clayton County, whereas you'll sit here for those 90 days until that hearing happens. If for whatever reason we don't have that hearing in those 90 days, then you'll be released then, okay? So again, the right for me to send you back, or I can go ahead and set the hearing date for you here. How would you like to proceed?
I want to hear.
Say it one more time.
Sure. Can you repeat that to me again?
Sure. Option number 1 is I will send you back to Virginia and they've got 30 days to come pick you up or we release you. Option 2, I'll set that hearing date for you and you'll have a hearing here in Clayton County. But if you choose to stay here in Clayton and you want that hearing date here, all that simply means is they have up to 90 days to come and get you, okay? If they don't get you if you don't have that hearing in that 90 days, then we'll let you go. So 1 is you'll go right back within 30 days. They'll come pick you up and take you back to Virginia. If they don't get you in time, we let you go. Option 2 is you prefer to sit here for 90 days and we'll give you a hearing. Again, the hearing is not about whether or not you are guilty of what they said you are. It'll be about, did they use the correct procedure? So it's procedure if you want to stay 90 days, or it's judge, go ahead and send me on back. I'll deal with this when I get back there. So let me ask it to you this way, Mr. Joshua, so you understand. Would you rather me just go ahead and send you back to Virginia now, or do you want to stay here for 90 days? Does that help you? Can you hear me, Mr. Joshua?
Yes, I can hear you.
Tell me what you're thinking. What questions can I answer for you?
So, if I be here for 90 days,
You're breaking up for me. Can you say it again?
meaning they are not coming to get me. Oh,
Say it one more time. You were breaking up.
hello? I mean, the third option, then the 90 days,
Mhm.
meaning I'll be here for 90 days. If they don't come for me, then I'm free.
No, 90 days is you're saying to me, Judge, I want to sit here. I want my hearing, and that hearing is not about what you did or didn't do. It's about did they do the correct procedure in order for you to get picked up. Okay? And you'll sit here for those 90 days until the hearing happens. If you say, Judge, I don't want to wait the 90 days for that hearing since it's not even about my case, just go ahead and send me back. Now, they've got 30 days to come get you. Virginia may not come right away. They got 30 days. And if they don't come in those 30, Clayton County will release you and let you go.
Don't send me back.
Okay, so you want the hearing day here?
Yes, sir.
Okay, and you understand that asking for that hearing means you can be here for up to 90 days. You understand?
No bill?
No bail.
Oh.
Tell me what you're thinking, sir. So I want to make sure you understand. Mr. Joshua, you got to be verbal. You got to speak, sir.
Yeah, yes, sir, I'm here.
Tell me what you are thinking. How would you like to proceed? Do you want to stay here for the 90 days, or do you want me to send you back? And in which case they have 30 days to get you, or we release you.
Don't send me back.
So you understand that you will be here 90 days with no bond. Do you understand that? You're saying don't send you back. I need you to understand what will then happen.
Meaning no bond and no bail.
Correct. For 90 days. Yes, sir. Up to 90 days.
So within that 90 days, can they come for me?
Say that it depends on how the hearing goes. If the hearing is in their favor, yes, they can come get you.
Don't send me back.
Okay. All right. So you understand you will be here 90 days, no bond, sir. All right. And then if the hearing is in their favor within those 90 days, they will come get you. Do you understand?
Yes. Sir,
Sir?
Do I get to discuss with my lawyer too first before I can decide, or I need to decide right now?
Whether you, yes, absolutely. Yeah, we just hadn't gotten it yet. I was going to talk about that with you. You will get a lawyer.
I have one.
You already have one?
Yes, sir.
Okay. Okay, no problem. But yes, you will get to speak with your lawyer. So I will show that you already you've retained him and paid him already?
Sir, I've done what?
You've already paid for a lawyer?
My mom took to a lawyer. My stepmom did.
Okay. Do you know she's already paid for it?
I know we have a lawyer, but I don't know whether it's been paid or not.
Okay. So until you know that, I see you're working. How much? You're only making about $500 a month?
Yeah, no, a week.
A week? Okay. So I'm gonna go ahead and appoint you a court-appointed lawyer that will help you here until you confirm that you've got somebody to help you on your case, okay?
Okay.
All right, sir. Any questions I can answer for you?
Can there be changes, if anything?
What do you mean?
If I speak to my lawyer and if we want to change anything, is it possible?
I mean, I can't tell you that, sir. Is it always possible? Absolutely. But I can't tell you if anything will change. I mean, that's why we're going through this now, to decide how you want to proceed.
Okay, sir.
Okay.
Yeah, don't say.
All right, and I just want to make sure before I go, because you seem to be confused and you're going back and forth. You understand, you'll be here until that hearing. If that hearing does not go in your favor, they're gonna come get you. Versus me sending you back, you dealing with the case and it being over with in 30 days. You understand you're gonna be here for a while, okay? No bond.
Right.
All right. All right, good luck to you, sir.
I'm glad you 2 seconds. You get to go back.
All right, sir. And are you Mr. Gates?
Yes.
All right, so Mr. Gates, you have several charges here that we will need to go through. Give me 1 second here, Mr. Gates.
That's right, so they can see you.
All right, so Mr. Gates, you were charged with 1 count of sexual battery against a minor, 1 count of cruelty to children against a minor, enticing a child for decent and purposes, a felony, computer pornography, a felony, child molestation, a felony, sexual exploitation of a minor, a felony, grooming of a minor for sexual offense or trafficking for sexual servitude, also a felony. So you have 7 counts, all felonies. Do you understand that, sir?
Yeah, yes, sir.
You do have special conditions, sir, and they're going to be to stay away from the alleged victim, Miss Ava Brown, who I believe was your niece, and her mother, Monica Robinson Gates. You understand that?
Yes, sir.
You also are to stay away from their home, the address of 313 Sandalwood Drive. Do you understand that?
Yes, sir.
Do you understand, sir, that any violation, any contact at all, whether it was to be nice, to email them, to apologize, anything, is going to have subject you to future additional charges, that being felony charges. Do you understand that?
Yes, sir.
Do you have any questions about that part of this, sir?
No, no, sir.
Okay. Now, you're going to get 2 court dates here. The first date's going to be your preliminary hearing because you're charged with felony, sir. It's going to be May 13th at 8:30 a.m. and that's going to be via Zoom. Your second court date is going to be May 15th of 2026, and that's also going to be via Zoom for your bond hearing. The reason you're getting that second day for a bond hearing, sir, is because I am placing you on a no bond for all 7 charges. Do you understand?
Yes.
Do you have any questions about anything?
No, sir.
All right, sir. So again, you're on a no bond. Your preliminary hearing is on the 13th of May. Your bond hearing is on the 15th of May. I'm looking over the information here, and based on what you've provided to me, sir, I am going to go ahead and grant you a court-appointed counsel free of charge. So you will have an attorney to assist you on your case. Okay.
Okay.
All right, sir. And that's all I have for you, unless you have any questions for me.
No, sir.
All right. Good luck to you, sir.
Stop the live stream. Oh, hey, Your Honor.
Yes, ma'am.
Oh, could you end the live stream?